Welcome once again to Lehto's Law. Here's Steve Lehto.
Had a whole bunch of people contact me and ask me to talk about the Bill Cosby situation. And several people said, I know you can't cover this, Steve, but I'm sure you saw it. Well, I can cover it. I'm just not going to get too heavily into the stuff that's non-legal. See, I am an attorney. I'll talk about the legal aspects of what happened with Bill Cosby's conviction just the other day. So Bill Cosby's been released from prison after the Pennsylvania Supreme Court overturned his sexual assault conviction. The Supreme Court of Pennsylvania overturned his conviction, said, let him out of jail right now, and you cannot retry him. And so there's a legal issue going on here, and it's kind of complicated, but once you hear it, I think, broken down to its basic terms, it'll make sense. Now, whether we agree with everything that everyone's done in the past in this case, that's not for us to say. I'm simply going to explain to you what the Supreme Court said, why they said it, and what their reasoning was. And again, that's the Pennsylvania State Supreme Court. I'm going to go with the version from the Philadelphia Inquirer. But I'm going to let you know right now, I've removed much of their editorializing. Jeremy Roebuck and Laura McChrystal wrote this version of the story. The 83-year-old comedian Bill Cosby served more than 2 years of a sentence that could have been up to 10 years in a state prison in Montgomery County. The Pennsylvania Supreme Court overturned the 2018 conviction on Wednesday, and they ordered him freed from prison. The court made no findings on the factual basis or on the evidence in the case. This has nothing to do with the evidence in the case. This is extremely important. So this ruling by the Supreme Court did not speak to whether or not they believe one side or the other when it comes to what happened. That's extremely important to understand, okay? What we're talking about is a legal issue that's got nothing to do with the credibility of the witnesses. So they're saying the victim could be telling the truth 100%. It doesn't matter. She could have been lying 100%. Doesn't matter. That is irrelevant to the issues at hand. Instead, they based their decision on a question that has plagued the case from the start: whether a prosecutor's decade-old promise that Cosby would not be charged in this case, whether that prohibited future district attorneys from filing charges against him in this case. So there was a prosecutor who was told there's a case. He examined all the evidence and came to the conclusion that he didn't think that they could get a conviction, decided not to bring charges. And that happens quite a bit. But for reasons that I'll explain in a second, he said, we will not charge Mr. Cosby, and we'll make a promise never to charge him in exchange for something he's going to do. The judge who wrote the opinion for the majority of the Pennsylvania Supreme Court found that that promise was binding, and they cited Cosby's reliance on that promise when he agreed to give incriminating testimony in a civil case that the victim had filed against him, and that testimony was then used in the trial where Cosby was convicted. So the judge wrote, this was an unconstitutional, coercive bait and switch, noting that such a vast due process violation required an equally drastic remedy. Ultimately, the court barred prosecutors from even retrying Cosby on the charges again, and that decision drew dissents from 3 members of the court. But that's not the point. The point is that the court has ruled, and some of the court says they should be allowed to retry him, just not use that evidence, but they all agree that the conviction needs to be overturned. So here's what happened. The victim comes forward, tells police, here's what happened. Bill Cosby attacked me. Then they take that to the prosecutor. Prosecutor examines all the evidence, goes, I don't think there's a case here. That not one that we can pursue and get a conviction on. But he understands that the victim also wants to sue Bill Cosby. And you can take a witness's deposition in a lawsuit and force them to testify, except if a witness is facing criminal charges, they can take the fifth and refuse to testify. So the prosecutor says, so that Bill Cosby could be forced to testify in the lawsuit, we basically said, we're not going to prosecute you on the criminal side of this. And so Bill Cosby did, in fact, sit for, I believe, more than one deposition where he testified without taking the fifth. And so those depositions and that lawsuit apparently led to a fairly large settlement that the victim got in a lawsuit against Bill Cosby. So the district attorney who brought the case that won the conviction actually got elected in 2015 in part by promising to put Cosby on trial. And he led the prosecution team, and now he's quick to point out that Cosby's conviction is based not on innocence, but rather a procedural issue irrelevant to the facts of the crime. Well, yes, that's true. His office did not say whether it intended to petition the court for a rehearing on the decision, because here's the thing. The Supreme Court said you guys cannot retry him again. Now, there is a process in many legal systems, including most states, that if a court makes a ruling, you have a time within which you can appeal that ruling. But of course, if you're at the Supreme Court, there's no place to go beyond that. But you can ask them for a rehearing. And the rehearing is based generally on the idea that the court has made such a horrible mistake that it needs to be corrected. The problem, of course, is that Supreme Courts don't make horrible mistakes because whatever they do is deemed to be correct. So to convince them they've made a horrible mistake is very, very difficult. So technically speaking, though, that option is still possible, where they could petition the court and say, look, we want you to reconsider this notion of whether or not we can retry him, and just retry him without using the excerpts of the deposition testimony. Because that's what they did. At the trial where they convicted him, they brought in the transcripts of these depositions that he sat for and said, okay, he's not testifying in court, here. We're going to bring in the transcripts of his testimony and show you what he testified to under oath in a lawsuit. But the lawsuit was regarding these general circumstances. So the issue that brought the case recently had been present from the beginning, and that began when the victim first reported to police in 2005 that she had been assaulted a year earlier. And there had been a first trial that ended with a hung jury after days of deliberations. And then there was a retrial where a second jury ultimately convicted him. So it was the prosecutor, whose name is Castor. When he first heard the reports about the alleged assault, he said he doubted her allegations would stand up in court given her delay in reporting them. And so he declined to bring it to trial. In doing so later, Castor said that he struck a deal with Cosby that he thought could help the victim find justice in a civil lawsuit. He said he promised Cosby would never be prosecuted because the comedian agreed to sit for a deposition in the civil case without asserting his Fifth Amendment rights against self-incrimination. That case ended with a $3.4 million settlement, reportedly. There is some argument about how this agreement was formalized, and testifying for Cosby's defense in 2016, Castor asserted that a vaguely worded news release he issued at the time of his decision not to charge Cosby was legally binding on all prosecutors who succeeded him in office. A Montgomery County judge said that Castor was not a credible witness and that there was no evidence beyond his word to support that the deal had ever existed. Well, unfortunately, the Supreme Court disagreed with that. Now, they did say that the legal reasoning that the prosecutor used was dubious, good word, but ruled that what mattered was Cosby and his lawyers reasonably believed it to be true, and they relied upon it. So Cosby's team was told, look, he will not be prosecuted so long as he sits and does depositions in the civil case without asserting the Fifth. And not asserting the Fifth, prosecutors thinking, is going to help the victim with her lawsuit. So Cosby goes in and testifies and does not take the Fifth. So the judge, writing for the Supreme Court, wrote, when a prosecutor makes an unconditional promise of non-prosecution, and when the defendant relies upon that guarantee to the detriment of his constitutional right not to testify, our criminal justice system demands that the promise be enforced. Excerpts from Cosby's deposition in the civil case were ultimately used against Cosby at trial, but the damage went far beyond that, the judge wrote, prompting the majority's decision to bar a retrial. Now, a couple dissenting judges say that they agree that Cosby's conviction should be overturned, but they think they should be allowed to retry him just without using the transcripts from the civil case. But they were in a minority on that one, so that'll lose. The dissent wrote, if district attorneys had the power to dole out irrevocable get-out-of-jail-free cards at will and without judicial oversight, it would invite a host of abuses. The judge wrote, adding in a footnote that one might reasonably wonder if such abuses were at work in this case, particularly given Castor's odd and ever-shifting explanations for his actions. Castor, meanwhile, said he felt vindicated by the court's decision, but remains indifferent about Cosby's release. He said, I don't feel any regret that he got out. I don't feel any satisfaction that he got out. He has no feelings either way. So, in case you're curious, the opinion of the case written by the Supreme Court in Pennsylvania is available to be read online. It is 79 pages long. I invite you to read it. Spent the better part of the afternoon yesterday at my desk, reading a thing on my screen. But the notion that people are granted immunity of some sort or another is something you're going to recognize as also being done in front of grand juries. So when a grand jury has been seated to investigate a crime, let's suppose there's some crime syndicate someplace. I'm giving you a hypothetical, nothing to do with the Cosby trial. Crime syndicate someplace, there's a kingpin and a bunch of lieutenants and a bunch of foot soldiers who do the actual criminal work. But they want to get the people at the top. So they grab a couple of the foot soldiers and they bring them into court and they say, look, we're going to put you in front of a grand jury. And you're going to testify in front of the grand jury and tell us what you know as we investigate this crime. And the grand jury is going to eventually issue indictments. And our goal is to get the people who run that criminal organization. And they bring in a guy who's a foot soldier in that organization. And they go, tell us what you do. And he crosses his arms and goes, I'm not going to testify. I take the fifth. Now, here's the problem. There's a good chance that that person, if my facts I just gave you are true, probably has broken the law because he's part of a criminal organization. That's my hypothetical. So as part of a criminal organization, probably is guilty of something. So asking that person to testify, or compelling them to testify, would violate the Fifth Amendment. But for years, our courts have said, oh, in this case, you can make the decision, a prosecutor can, make the decision that if this person is not the person we're really going after, and it would make sense to grant them immunity in an attempt to get the people above them, we can do that. So you give this person a break and say, look, we won't charge you for anything you say in here, in this courtroom, in this grand jury proceeding. And these are closed, sealed from the public. And you're going to testify. And nothing you say will be used against you, can be used against nothing. We'll grant you immunity. Now if the person takes a fifth, you go, what are you taking the fifth for? You can't be prosecuted. You've got immunity. And then a judge can hold the person in contempt and say, you've been granted immunity. You've got no right to take the fifth. Because your only excuse to take the fifth is, I don't want to be forced to testify against myself. But if you cannot be prosecuted, you ain't testifying against yourself. You can't be. So that happens a lot. And that puts those foot soldiers in an uncomfortable situation. Because they have to go, wait a second. Now my choice is sing like a bird and people above me will be very upset. Or take the contempt charge. And you hear about that also. And so that's another story altogether. But the real issue here is that this is an unusual situation. And this prosecutor probably should have done something a little more with this, such as gone into court and put it on the record. Okay? And so if the prosecutor's working with Cosby's attorneys and they have this agreement, you would formalize it by the parties coming into court, and the judge would come out, call the case, and the prosecutor would then say, we've had a discussion with the other side's attorneys, and there's, as you know, potential criminal charges and potential civil charges, lawsuit, and we've struck a deal where he's going to testify if we agree not to prosecute. And then a judge would look at that and go, okay, does that make sense? Does it comport with Pennsylvania law? Is this good for public policy? Does this make sense? And a judge could look at that and go, no, it's not how we do this. Judge could do that. Or a judge could say, okay, why don't you explain to me why you think this case wouldn't work as a criminal prosecution, but you think it might work as a civil? And one of the most obvious reasons there, of course, is that there's different standards of proof. Okay, criminal, of course, is beyond a reasonable doubt. And in a civil case, it's a preponderance, more likely than not. That's why a lot of times you'll hear about somebody being exonerated, found not guilty in a trial, but hit with a big, big judgment in a civil lawsuit. So there you go. So that's what happened with Bill Cosby. Again, the court did not address, did not weigh in on, did not talk about, did not touch anything to do with the credibility of the witnesses in this case. And they ain't saying we don't believe them. They're simply saying there's a problem because a prosecutor did tell Bill Cosby and his attorneys that if you sit for depositions in this case, we will not prosecute you. And the court's saying if that agreement was made and Bill Cosby relied upon it, then the future district attorneys are bound by that. Otherwise, what do you got? So it is a very unusual turn of events. He spent a couple of years in prison, but he's out now, and they cannot retry him for that case. From the Philadelphia Inquirer, Jeremy Roebuck and Laura McChrystal wrote it. Bill Cosby is released from prison after the Pennsylvania Supreme Court overturns his sexual assault conviction. It was sent to me by everyone. D. Wilburn, Mark, Jennifer, Caleb, Farsights, Philip, Paul, David, Greg, Mark, Randy, Jesse, and Steve. Not me. Questions or comments, put them below. Let's talk to you later. Bye-bye.
Thank you for watching Lehto's Law. Experience is something you don't get until just after you need it.